No, I have not seen them online.
My
I
lord,
have
the
not.
claimant lawyer is here.
You said?
The claimant's lawyer is here.
Good morning, my lord.
Morning. What of the other counsel? Has he been informed of this?
No, there is no counsel on the other side.
Okay. This matter is for judgment. By the general form of complaint dated 13th day of October 2021 and filed on the same date, accompanied by statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on at the trial, and photocopies of documents to be tendered as exhibit. The claimant's claim against the defendant as per paragraph 23 of the statement of facts as follows. I am going to skip reading the reliefs. They are total. They are 10 in number. The defendants were served with the originating process commencing this suit, but they failed and neglected to file memorandum of appearance or file defense to the claimant suit. They were also not represented in court throughout the duration of the trial. The first claimant testified in proof of his case as CW1. After identifying his witness statement on oath, he relied on it as evidence in this case. CW1 tendered 7 documents in evidence. They were admitted in evidence and marked as exhibit A, B, C, D, E, F1, and 2. The witness was discharged due to absence of defendant to cross-examine him. The second claimant also testified as CW2 in proof of her case. CW2 identified her witness statement on oath and adopted it as her evidence in this case. No document was tendered by CW2. One Ubi Agu testified as CW3 in proof of the claimant's case. He identified his witness statement on oath. He relied on it as his evidence in this case. He did not tender any document. He was discharged due to absence of the defendant to cross-examine him. A resume of the facts that led to the filing of this suit are that the claimants are husbands and wife engaged by the first defendant as driver and cooks, respectively. The claimants were allowed to reside in the official quarters of the first defendant, their employer. The claimants were staying in the official quarters until the day they and their properties were thrown out of their official residence by the second defendant and his cohort. On the 7th day of July 2021, the claimant, upon resumption at work, notified the second defendant of lack of fuel in the official vehicle he was assigned to drive. But contrary to expectation of the claimant, of the first claimant, the second defendant reaction was to inform the first claimant that he had been fired. On the 8th day of August 2021, the first claimant was in his official quarters sleeping, arrested, when the second defendant trespassed, intruded, and broke open the first defendant to open the claimant's official residence in company of 4 boys. Upon breaking open the claimant's official residence, the second defendant beat up the claimant and consistently first claimant and consistently slapping him on his right ear. The second defendant also ordered the 4 boys to throw out the claimant's properties in the rain prior to 8th of October, 8th of August 2021. CW3 gave the first claimant the sum of 1 million naira to keep in safe custody in furtherance of a business purpose. On the seventh day, that is on the 7th day of August 2021, which money was kept in the official residence. After throwing claimant's properties in the rain and simultaneously locking up the claimant's official residence by the second defendant, the first claimant discovered that the said 1 million naira given to him by his friend CW3 was nowhere to be found. The second claimant was still in the employ of the defendant even after the determination of the contract of employment of the first claimant. The second claimant's contract was determined on the 8th of August 2021. The submission the day they were thrown out of their official residence. The submission of the claimant. His argument, this matter came up before the court on 22nd day of January 2025 for adoption of final written addresses. Philip O. Ofla Esquire counsel for the claimant adopted the final written address of the claimants as his argument. Counsel also urged the court to grant the relief sought by the claimant. In the final written address, a single issue was formulated for determination, to which, whether having regard to the state of pleading evidence or record and the provisions of the law, the claimant have proved their case to entitle them to relief sought. In arguing the sole issue, counsel submitted that it is now established position of the law where an employment is such that appointment and termination is governed by statute or contain a regulation derived from statutory provision, the employment has statutory labor. To support his submission, counsel relied on case of EKSU and others versus Pajembola and others, where the Court of Appeal held and court an employment is said to have statutory labor, where the appointment and the determination is protected by statute or laid down regulation made to govern the procedure for employment and discipline of an employee. In the event of termination, strict adherence must be accorded to the statute creating the employment, and it cannot be waived. Counsel also submitted that where employment is with statutory labor, any termination without strict adherence to the statute or regulation creating the employment is considered null and void. In support of this contention, reliance was placed on the case of Bamboye versus University of Ilorin and that of Comptroller General of Customs versus Gusau and another, where the Supreme Court held the law is settled that the only way to terminate a contract of service with statutory labor is to adhere to the procedure laid down in the statute. See also the case of Chief of Naval Staff and another versus Opanachi, and case of Longe and Test Bank of Nigeria. Counsel, in the light of the foregoing, submitted that it is evident that the claimant's employment come under this category of employment with statutory labor, and that the defendants acted in disregard of the law as it relates to termination of employment, and consequently rendered this void. The defendants throwing the properties of the claimants out and sent the claimants out is against the laid down regulation by law, as termination is null and void. Counsel also submitted that the first claimant was beaten and treated inhumanly, and to the extent of that he has to engage services of medical personnel as shown by exhibit before the court. It is also submission of counsel that the claimants through their pleading and evidence in court have established that they have employment with the defendant. Counsel submitted that the standard of proof in civil service is on balance of probabilities of preponderance of evidence, not beyond reasonable doubt. To support this submission, counsel relied on the case of Jaji versus Oloa. Counsel also submitted that in the instant case, the defendant did not tender any document to disprove any of the claimant's contention. Consequently, the defendant's side of imaginary scale is empty. The evidence of the claimant placed on the lost imaginary scale, being the only evidence on that scale, is conclusive proof of this case before the honorable court. Counsel asked the court to so hold and decide in favor of the claimant. Counsel also relied on the case of Kolawole versus LAO Nigeria Limited. On admissibility of Exhibit A to F1 and 2, counsel submitted very strongly that the hallmark of admissibility is relevance. Relevance determines admissibility. The moment it is determined that the evidence is relevant for the purpose of determination of a fact in issue, the court is bound to admit it in evidence. In support of this contention, counsel relied on the case of Oka versus RSH and PDA. Counsel continued his submission that Exhibit A to F1 and 2 are all the documents of the claimants consisting of appointment letters and medical reports for the inhuman treatment claimant received and destruction of their household properties as seen in Exhibit F1 and 2. Counsel argues that it is right law that a party cannot benefit from his own wrong. To support this submission, reliance was placed on the case of Salah versus Monguno. According to counsel, all the documents tendered were pleaded. It is also submission of counsel that all the documents tendered by the claimants which were admitted in evidence shows that the claimants were treated badly by the second defendant as if they were common slaves in their own country. Counsel also submitted that CW2 and CW3 testified how the sum of 1 million was stolen from the claimants when their properties were thrown out by the second defendant and his agent. The claimants were beaten by the defendant and their agent. In concluding his submission, counsel argued that the claimants were employed by the first defendant. They worked diligently for 3 years and above without problem of any kind, not even a query. The second defendant threw their properties and terminated their job without due process. The claimants have proved their case. The defendants perpetuate wickedness against the claimant. The action of the claimants amount to outright wickedness. Court decision. I have considered the processes filed in this suit, the evidence laid, and the written and oral submissions of counsel. As pointed out earlier in this judgment, the defendant, despite having been served with the originating process commencing this suit and hearing notices, they failed and neglected to file memorandum of appearance or file defense to the claim of the claimant. What this attitude of the defendant portends is that they either do not have any defense or are not interested in defending the suit. By the rules of pleading, by the rules of pleadings, absence of defense means admission is taken as admission of the facts pleaded by the other party. In law, the net effect of the failure of the defendants to file pleadings in this case so as to counter the assertions of the claimant in his pleading stand unchallenged and are deemed admitted and established. See the case of Okebo versus Police Council and Consolidated Resources Limited versus Abofan Ventures Nigeria Limited. It is also right that the effect of a defendant's failure to furnish evidence in defense of claims against him or against them at the trial is that he is presumed to have admitted the case made against him by the claimant. See the case of Ipeta versus Shell Petroleum Development Corporation of Nigeria. See also Okoli versus Marinho. However, these do not translate to automatic victory for the claimant. This is because claimant must succeed on the strength of his case and not rely on the weakness of the defense and the absence of statement of defense or evidence laid by the defendant does not exonerate responsibility on the claimant to prove his claim. See the case of Harka Air Services Limited versus Keazo. See also Ogunyade versus Oshunkwe. The benefit derived by a claimant is that in view of failure of the defendants to either file statement of defense and only the evidence, the onus is on the claimant will be discharged on minimal evidence as there is no evidence to put on the other side of the imaginary scale. See Adewi versus Oduefe and Consolidated Resources Limited versus Aboko Ventures. See also Bauchi State Government versus Samail Ahmadu, Gumau, and another. It is in the light of the foregoing position of the law that I shall consider whether the claimants have succeeded in proving entitlement to any of the relief sought. However, before delving into the issues calling for determination, I shall endeavor to deal with preliminary issues of admissibility of exhibits tendered by the claimant before the court marked as Exhibit A to F1 and 2. Counsel for the claimant has, in his final written address, dedicated certain portions of the address to issue of admissibility of exhibit before the court. Let me say that by this submission, counsel for the claimant seems to be confused on the admissibility of evidence with probative value of evidence. There is a world of difference between the two. Relevance and admissibility of a document are separate matters in contradistinction from the way to be attached to it. See Dalek Nigeria Limited versus Oil Mineral Producing Area Development Commission. See also Abubakar versus Chooks and UTC Nigeria PLC versus Lawal. While admissibility depends on relevance, consistency with the pleadings, and compliance with the Evidence Act, probative value depends on proof. Evidence is said to have probative value where it tends to prove an issue in dispute. See Blessing versus Federal Republic of Nigeria. See Nissan versus Peter Side. Thus, the fact that evidence, oral or documentary, is admitted with or without any objection in the course of the trial or without any objection does not make it to have weight. In fact, it is at the stage of writing judgment that probative value of evidence will be considered by the court. It is irrelevant that the witness who tendered the evidence in question was not cross-examined. See the case of Salah versus Sabah, Exhibit Aboa. Exhibit A and B are photocopies of letters of employment of the claimants by first defendant, issued to them by the first defendant upon their employment. The first claimant in tendering this exhibit had informed the court of CW1. She has informed the court that this exhibit has informed the court the original of this exhibit were missing. That's why they have to tender photocopies. Being private document, photocopies are acceptable in evidence, and I accept them in evidence. And they are evidence of employment of the first and second defendant or first and second claimants by the first defendant. Exhibit C is a photocopy of the Nigerian Police Force medical compile. This document, Exhibit C, is a public document. In law, The only acceptable secondary evidence of a public document is certified true copy. Exhibit not being certified true copy and also not being original has no a public document. A public document not being a certified true copy or being original has no evidential value in law. It is hereby XBC is hereby discountenanced for not for not for not for not complying for not being in compliance with the provision of Section 104 of the Evidence Act, like Exhibit C, Exhibit D being a public document. Only acceptable secondary evidence is certified true copy and not photocopy of the said document. Exhibit D is as well lack evidential value, is also hereby discountenanced. Exhibit E is the original reception payment of professional fees at appropriate time. This document will be considered. Exhibit F 1 and 2 are photographs. The maker of the photograph has not been called as witness of this case. CW1, who tendered them, was not maker of the said document. In the circumstances, the said document does not command any evidential value. It is also discountenanced. Another preliminary issue that called for resolution is the stance of the counsel for the claimant that the claimant's contract of service is one that has statutory label. In making this submission, counsel placed reliance on the cases of Bamboy versus University of Ilorin and the case of Controller General of Custom versus Busau. He also relied on the case of Chief Naval Staff versus and that of Nonge versus First Bank of Nigeria PLC, where the Supreme Court has made it clear that employment having statutory labor for employment having statutory labor to be determined, the procedure laid down by the statute or the conditions of service which derive its forth from the statute must strictly be followed. Failing which the termination or dismissal of the employee will be null and void. The question now begging for answer is whether Lemon's employment is one that has statutory labor, as the counsel for the as counsel for the claimant seems to have pontificated. I have combed the entire pleadings of the claimants as well as the evidence adduced before the court. There are no facts pleaded regarding claimants' employment having statutory labor. There is also nowhere the claimants have mentioned the statute that governs their employment or the conditions of or tender the condition of service that derive its force from a statute which governs their employment. The law is that any contract not governed by a statute is contract of service under the common law. What is even baffling is the fact that the condition of service which was passed on to the which made person to statute has not been tendered before the court. In the circumstances, the case of the claimants, the employment of the claimant does not have any statutory labor. It is an ordinary master-servant employment governed by the common law. In the circumstances, the submission of counsel for the claimants is based on great misconception of the law. Having dealt with the preliminary issues of admissibility, evidential value, exhibit tendered before the court and statutory labor, I shall now proceed to determine the claims of the claimant as adumbrated in the paragraph 23 of the statement of facts. All in all, there are a total of 10 reliefs being sought by the claimant. The law is well settled that Claim before the court is circumscribed by relief sought, and the duty of the claimant is to adduce relevant cogent evidence in proof of claim before the court, as the claim may be granted in toto or partially granted, but not relief which has not been claimed can be granted or more than what the claimant has claimed. See the case of Gabriel Atibi versus Kabel Metal Nigeria Limited. In relief one, the claimant are seeking for declaration that their dismissal by the defendant is wrongful. Now, to determine whether the dismissal of the claimant was correct or wrong, the terms of employment of the aggrieved employees of the claimant must be examined to see whether the correct procedure was followed. Where there is departure from the prescribed procedure or a violation of the elementary rules of natural justice, then the dismissal is unlawful. See the case of Lanyan versus University of Lagos. See also Adedeji versus Police Service Commission. See also Nwabosi versus ACB and Eze versus Supreme Bank. In the case at hand, the terms of employment of the claimants are as contained in Exhibits A and B. I have perused this exhibit. There is nothing that prescribe in them how to dismiss employee, but there is a provision for termination on probation. In the case at hand, having regard to the period the claimants have served, they are deemed to have been confirmed, having served for more than 3 months with the defendant. In the case at hand, the case of the claimant is on dismissal. In law, dismissal of employee must be based on misconduct. For dismissal of employee to be valid, must be based on misconduct of the employee. From the evidence of the claimant, they were never accused of any misconduct, nor was any disciplinary action taken against them. In the circumstances and in the absence of a written letter of dismissal saying that claimants have been fired or have been dismissed from service, in the absence of a written letter of dismissal, the saying that claimants have been fired or should not report for duty can only amount to termination and not dismissal in law. For termination to be valid, where the terms and conditions of service are silent on procedure, the law implies that for the termination to be proper, the employee should be given notice of termination or payment of salary in lieu of termination. In the case at hand, the way and manner the claimant's employment were terminated clearly shows that they were never given any notice or paid any money or salary in lieu of notice. On the notice that is appropriate in case of termination of claimant, in the absence of provisions in the condition of service, the court has a discretion to consider reasonable notice as sufficient for the purpose of notice. Taking into consideration the service rendered by the claimants in this case, I am of the view that 1 month's notice is sufficient to terminate the claimant's employment or payment of 1 month's salary in lieu of notice. In the circumstances, the claimants are entitled to notice of payment of salary in lieu of notice. In view of the fact that they were not given notice and were not given salary in lieu of notice, they are entitled to be given 1 month's salary in lieu of notice. I find and hold. Or reliefs 2 and 3. The claimants are seeking for payment of salary from date of termination till the date of judgment. The law is well settled that an employee, whether termination was proper or wrongful, cannot reject such termination. Once termination has been done, it cannot be rejected by an employee. Therefore, he cannot be paid salaries from date of termination to date of judgment for work not done. Claimants in this case are not entitled to relief 2 and 3. Relief 2 and 3 are hereby refused. On relief 4, the first claimant is paying for payment of 2 million naira for wrongful termination. I have earlier found that there is for wrongful dismissal. I have earlier found out that there is no dismissal since claimant was not accused of any misconduct. The fact as disclosed by the pleadings and evidence is wrongful termination, and a wrongful termination, the damages payable is for is salary for the period of notice that the claimant is entitled to. Having found that the claimant is entitled to 1 month salary of notice, and having granted that he is not entitled to relief 4 as claimed, relief 4 is also refused for having not been established. I now go to relief 5, which is for an order mandating the defendant to pay first claimant the sum of 3 million naira as damages for beating inflicted on him and damages to right ear. There is no iota of evidence to prove this claim apart from oral account of the claimant. The document tendered in proof of this relief has been found have been found by the court. The documents tendered in proof of this relief, i.e., exhibits C and D, have been found not to have any evidential value by the court. In the circumstances, they cannot prove anything. They cannot prove anything. They are public documents that require certification. They have not been certified. They have no evidential value. They cannot prove anything. And secondly, the exhibit which purport to be a medical report has not been tendered by the maker. The claimant is not maker, is not a doctor that can appropriately tender that exhibit in evidence. In the circumstances, exhibit C and D, having violated section 104 of the Evidence Act, they are inadmissible in law. They cannot prove anything in favor of the claimant. They are hereby discountenanced. A relief 5 is hereby refused for not having been proved. I now go to relief 6, which is for an order mandating the defendants to pay 3 million naira to the claimant for as damages for destruction and damage occasioned by the defendant to the properties of the claimant by throwing them into the rain from their residential quarters. Exhibit F1 and F2, which were tendered to prove this relief, has been discountenanced by this court due to lack of evidential value, as the maker of the document did not was not called as one of the witnesses in this case. In addition, the claim is that of special damages. In law, for a special damages, it has to be specifically pleaded, particularized, and strictly proved. The claimants failed to satisfy this requirement for proof of special damages. There was no particularization and there was no strict proof. In the circumstances, relief 6 failed and same is hereby dismissed. Or relief 7, it is for an order mandating the defendants to pay the sum of 1 million naira for safekeeping. I have listened attentively to CW2 and CW3 in their evidence in chief. There is nothing to show that CW3 actually gave 1 million naira to the defendant for safekeeping for business, apart from oral account of the said giving of 1 million naira. It is my view. It is surprising in this era of technology and where keeping of money not in bank is deprecated by law, for an individual to give the sum of 1 million naira to a fellow individual for safekeeping in his house. There is also no any evidence to show the kind of business to be done with the said money and who is to conduct the said business. I did not believe the story of CW1 and CW3 on the issue of 1 million naira for safekeeping in the house, which they said was allegedly stolen by the second defendant and his cohort. There is no evidence. The allegation of stealing is a criminal in nature. It requires proof beyond reasonable doubt. There is no such proof in this case. In the circumstances, relief 6 failed, same is hereby refused. Relief 7, sorry, failed, same is hereby refused. And now goes to relief 8 and 9, which are for payment of counsel services rendered by the claimant rendered by the counsel for the claimant in prosecuting their case before the court. The law is well settled that professional fees not being part of course of action cannot be granted by the court, cannot be granted. Therefore, the claimants have failed to prove that they have failed to prove reliefs 7, 8, and 9. Same are hereby refused. I now go to relief 10, which is for 20 million naira general damages for for emotional trauma, pains, and stress as a result of the defendant's illegal activities. There is no evidence adduced by the claimant to support this claim. The evidences already before the court, which may have established that is exhibit F1 and 2 have been found not to have any evidential value. In the circumstances, relief 10 fail and same is hereby dismissed. From all I have been saying, the claimant have only succeeded in proving entitlement to payment of 1 month's salary in lieu of notice of termination. The defendants are hereby ordered to pay to the first and second claimant 1 month's salaries in lieu of notice. For the first claimant, the defendant is to pay him the sum of 43,000 naira, which is his 1 month's salary, as in lieu of notice of termination. For the second defendant, she is to be paid the sum of 24,000 naira, which is her salary, in lieu, which is 1 month's salary, as salary in lieu of notice of termination. The claimants are hereby entitled to cost which I assess in the sum of 300,000 naira each. The defendant shall pay to each of the claimants 300,000 naira in lieu of 300,000 naira as cost of action. All monetary aspects of this judgment shall be paid within 30 days from today, failing which 10% simple interest per annum shall apply. Judgment is hereby entered accordingly.
As the court pleases.
Appearance, my lord, before with almost humiliating Philip Ona Upla for the claimant.
You said?
My lord, I have not taken my appearance because I arrived a bit late. Philip Ona Upla for.
I have recorded you.
Oh, thank you, my lord. We are most grateful.
You are
The
welcome.
well research and well.
Thank you, counsel. You are welcome.
Thank you.
What's the next case?
My lord, the ruling.
That is the next case now.
Okay, my lord. Suit number NICN CA20M 2025 between Nigeria Union of Pensioners and 1 Mr. Basi B. Okon, 2 Chief Ignatius A. Ofyong, 3 Chief Ignatius I. Ntui, and 8 others. My lord, the parties are absent.
Appearance.
May it please my lord, F.N. Nachamada.
Yes.
F.N. Nachamada, my appearance is for the claimant judgment creditor applicant in this case.
Okay. This is the ruling of the court. This deals with motion ex parte dated 14th day of March 2025 and filed on the 17th day of March 2025. The application was brought pursuant to order 4, Rule 8 of the Judgment Enforcement Rules made pursuant to Section 94 of the Sheriffs and Civil Process Act, Cap S6 LFN 2004. The application is praying for an order for leave for the claimant judgment creditor applicant to levy execution of the judgment of this honorable court in suit number ICN/CA/04/2016, delivered on the 12th day of July 2026 by Honorable Court Justice Ian Abakoba of blessed memory after 6 years of the delivery of the said judgment, and for such further orders as this Honorable Court may deem fit to make in the circumstances. The application is supported by a 5-paragraph affidavit, 1:1 A.D. Bernard Ede, the Secretary of the Cross River State Council of the Judgment Creditor Applicant. A written address was also filed along with the motion ex parte. F.N. Nachamada Esquire, counsel for the judgment creditor applicant, relied on the abatements contained in the affidavit in support. Counsel also adopted the written address filed along with the application as his argument in this application. Counsel asked the court to grant the application as the judgment debtors are in disobedience of the court judgment. In the affidavit in support, the judgment creditor in suit number NICN/CA/2016 were restrained from collecting check-off dues from the claimant's members in Cross River State. Despite this judgment, the judgment debtors still went in collecting check-off dues from the claimant's members without remitting them to the claimant judgment creditor. From 12th of July 2026, when the judgment was delivered, to date is more than 6 years, period stipulating the enforcement. See Order 4 Rule 8. The claimant judgment creditor needs leave of court to enforce the judgment against the judgment debtor. In the written address, it was argued that the judgment sought to be enforced was delivered on the 12th day of July 2016 in suit number NICN/CS/04/2016, which is more than 6 years from the date it was delivered. In order to enforce the judgment, leave of this court must first be sought and obtained. To support this argument, reference was made to Order 4 Rule 8 of the rules of the judgment enforcement rules. Council submitted that the rules did not require any notice to be given of this application. Council asked the court to grant the application as prayed, so as to stop the disobedience of the court's order. I have perused the motion ex parte, the affidavit in support, and the written and oral submissions of counsel for the claimant judgment creditor applicant. There is no doubt this court has handed down judgment on the 12th day of July 2026 in suit number NICN/CS/04/2016. There is also no dispute that the judgment has not been enforced. The law requires obedience to judgment or order of court once delivered without any prompting. Where there is non-compliance with the judgment or order of court, such judgment can be enforced within two or 6 years, depending on the parties to which the judgment will be enforced against. Where a judgment creditor has delayed enforcement of judgment beyond 2 or 6 years, as the case may be, the judgment creditor must first and foremost sought for and obtain leave of court before taking steps to enforce the judgment. The claimant judgment creditor in this case is seeking to enforce the judgment of 12th day of July 2026. The reason given for this application is that the judgment debtor respondent have continued with the deduction of check-off dues despite the fact that this court has ordered such deduction to be stopped, and they are not remitting the deductions made to the judgment creditor applicant. I have perused the judgment of the court, and it is clear to me from the judgment that the order that is enforceable is against the 11th defendant. In the circumstances, if this judgment is to be enforced against this 11th defendant, in order to put a stop to continuous violation of the restraining order of this court, I hereby grant the judgment creditor leave to enforce the judgment of this court delivered on the 12th day of July 2026. Therefore, leave is hereby granted to the judgment creditor to enforce the said judgment as delivered on 12th day of July 2026. Ruling is entered accordingly.
As the court pleases. Thank you, my lord.
Yes. You're welcome. Yes, Registrar, call the next case.
Suit number NICN CA 12/2022 between Mr. Christopher Okoro and Eco Bank Nigeria Limited.
Good morning, my lord. EcoBank Nigeria Limited.
Okay. My lord, the defendant is represented. Your name, sir?
My name is Dembo Francis.
Eno Francis.
Dembo Francis. Dembo is spelled D-E-H-I-M-B-O. Dembo Francis.
Okay. And your position, sir?
HR manager.
My lord, the claimant is absent. Is he there? Not there. My lord, the claimant is absent.
What is the name of the representative of the defendant?
Dembo Francis, my lord. Dembo is spelled D-E-H-I-M-B-O, my lord. Dembo Francis.
Eibo.
Dembo Francis, my lord. Dembo is spelled D-E-H-I-M-B-O, my lord. Dembo Francis.
Okay,
There.
Eibo Francis.
Very well, my lord.
You say your position?
HR manager, my lord.
Yes, appearance. Appearance. You have to unmute yourself, counsel. We can't hear you. You have muted
Maybe,
yourself.
my lord.
Yes.
Very sorry, my lord.
Yes.
Maybe, my lord. Dr. Emmanuel Sani. My lord, I appear with BAEU for the claimant.
You appear with who?
BAEUIYUN.
Where is he? I have to see the person before I record him.
My lord.
Yes. What is his name?
What is his name?
Yes,
BAEU.
the name of the person you are appearing with.
BA as in initial.
VA who?
IYUN.
IYUN. Yes. Are you appearing for claimant?
Yes, my lord. Appearance is for the claimant.
Yes. Any appearance for the defendant?
My lord, we prefer.
Yes.
I appear for the IJ.
Yes.
My lord, the matter was for the fan.
You said?
I said, my lord, related to today's defense.
Yes. Where is the witness?
My lord, the witness and
Swearing.
Yes. Register administer also on the witness virtually.
Yes, my lord. Witness. Defense witness, are you a Christian or you are a Muslim?
You have to unmute yourself. You have muted yourself.
My lord,
I'm a Christian, my lord.
Yes.
Okay. You want to swear with the Holy Bible or you want to affirm?
I want to swear.
With the Holy Bible.
Yes.
You raise your hand up like this, your right hand. Thank you. And you repeat after me. Say I.
I,
Insert your name, sir.
Dembo Francis.
Swear in the name of the Almighty God
Swear in the name of the Almighty God.
that the evidence I shall give in this case
That the evidence I shall give in this case
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
My Lord, the witness is on oath sworn with the Holy Bible.
Yes. Mr. Akiki.
yes. Yes. Please tell the court.
Yes.
Please tell
Yes.
the court your
I can't hear you, please. Tell the court what? Yes, I can hear you now.
name, your name.
Okay, my name. Okay. Dembo Francis, my lord.
Be stable with your system, please.
Dembo Francis, my lord.
Yes.
Where do you do and what do you do?
I work with EcoBank Nigeria Limited. I'm in the banking profession, my lord.
You said?
I work with EcoBank Nigeria Limited. I'm in the banking profession, my lord.
Yes.
You recall that you made statement on oath in relation on the 10th day of July 2020. Am I correct?
Very well, my lord.
What do you want to do with the statement?
Yeah, I want the court to adopt that my oral testimony in this matter, my lord.
Yes.
My Lord, respectfully, accompanying the defendant process were 5 listed as 1 to 5. My Lord, they said have been shown the man counsel.
Yes.
We intend to 1 to 3, while number and number 5 has already been by the claimant. So we don't want to take it again. We will rely on that.
Yes.
My Lord, the 3 documents have been shown. So listed as
Mr. Akitu.
yes, my Lord.
You are not stable. We can't hear you very well, please. And you are the only one we cannot hear very well.
My Lord, I apologize. Maybe let me share the system with the claimant's counsel so that it's very loud. Yes, my Lord. My Lord, I don't know if my Lord can hear me now.
Yes.
As a court, please. My Lord, we said we listed 5 documents.
Yes.
Accompanying our defense.
Yes.
Out of the 5 documents, we are only tendering number 1, 2, and 3.
Okay.
Number 4 and 5 has already been tendered by the claimant.
Yes. Mr. Sani.
Yes, my Lord.
Respectfully, my Lord.
Are you
Respectfully,
objecting?
my Lord. We have indicated that we'll be objecting to number 3, but being at its may, we'll raise the objection in our addresses and only.
With the consent of counsel, the exhibit listed as 1 to 3 in the list of documents to be tendered by the defendant as exhibit are hereby admitted in evidence marked as exhibit DW1A, DW1B, and DWC. However, parties are free to address the court on the admissibility of exhibit DW3 in their final written addresses. Yes.
My lord, that will be all for the defendant's witnessing.
Sani, any cross-examination?
Respectfully, my lord, yes, just some few questions, my lord.
Yes. Can we go ahead?
Yes, my lord. Witness.
Yes, I can hear you.
When did you join the defendant's employ?
I joined the defendant September 2005, my lord.
You joined when?
September 2005, my lord.
September
2005, my lord. 2005, my lord. 2005, my lord.
Okay, 2005.
Yes, my lord.
Yes.
When did you assume the role of the HR manager or your current position?
Okay, so I've always been in HR. And yeah, I assume my current position in 2017 precisely.
He said, when did you assume in your current position? That is the question.
I said 2017 precisely, my lord.
17th?
2017 precisely, my lord. 2017, my lord.
Yes. Dr. Sani, any other question?
Clearly, as you said, you've always been in HR.
I've always been in HR from day one, yeah.
On which side of the divide did you join the current claimant, your defendant's employee? Were you in Oceanic Bank? You know, it's a merger.
I was in Oceanic Bank, my lord.
You were in Oceanic Bank.
I was in Oceanic Bank, my lord.
And you transited?
I transited very well, correct.
I cannot hear you well, please.
Yes, I was in Oceanic Bank, my lord. So I transited from Oceanic Bank to Eco Bank, my lord.
You transfer from Oceanic Bank?
To Eco Bank, my lord.
Okay.
Yeah.
As a very reputable bank, I'm sure Eco Bank is a very reputable bank.
Very well, my lord.
And that means you have a very robust risk management system in relation to loans.
Yes.
Yes, to some extent, my lord.
That what? Please, you have to explain. I have to write what you say.
So, my lord, to some extent, yes, we have a robust risk management and loan recovery process. And I said there are some peculiarities attached to the process, my lord.
Yes. Any other question?
Now, before loan is issued by CBN regulation, the first thing to do before you issue loan to a prospective customer is to do the normal due diligence as it regards KYC.
Yes,
is that
my lord,
correct?
it is statutory, my lord. It's very, very correct.
Yes. Any other question?
Can you tell this? Can you expatiate or explain or throw light on what KYC entails in the banking system?
So, my lord, KYC means know your customer, my lord. It's just an act of ensuring that you have full details of your customer's identity and address.
Yes.
So
Yes.
as part of the risk management system, before loans are given, you ascertain the recoverability of the loan, the capacity of the the customer to repay, and you ensure that you have adequate securities for those loans. Is that correct?
Not exactly, my lord. My lord, the process of loan entails a relationship manager to bring in a prospect to the bank. The policy of the bank requires the relationship manager to ensure that all the listed qualities, the ability to repay, to ensure recovery is in place. And the relationship manager also manages the relationship to ensure that the loans are recovered, my lord.
Yes.
You agree with me, or would I say, I would say it is correct to state that there are layers, several layers of authorization before loans are approved and eventually disbursed.
Yes, my lord, there are, but majorly, approval is always hinged on the comfort or the guarantee and assurances from the relationship manager, my lord, to ensure recovery, my lord.
Yes.
On whom lies the final responsibility of approval?
So it's a chain. It goes from the RM to the branch manager, then to the risk management department of the bank.
He said the final approval. Who is in charge of final approval?
So final approval is the head of the business, my lord. That's head of marketing, head of the business, my lord.
Head of the branch?
Head of the business, my lord. Business head in the head office, my lord.
Yes. Any other question?
That means approval comes from the head office after thorough scrutiny by the risk management team. That is correct.
So because the request is coming from the branch or other location outside Lagos, the risk management and the management of the bank believe in their relationship managers to have ensured that all the risk has been covered at their end. So on the basis of that, the head office approves the loan.
What is the function of the risk? Then what is the function of the risk management team?
So the function of risk management is to assess a proposal from the relationship manager. If the relationship manager has confirmed that he has done his due diligence and confirmed that the receiver of the loan or the beneficiary of the loan has the capacity to pay, then the risk manager will only review in line with the recommendation of the relationship manager, and they will approve it.
Yes.
Have you ever worked in the risk management office?
I have not, but I relate to them very well.
What are your core functions?
So my core function as HR manager is to ensure that I ensure my branch are staffed. I ensure that my staff are engaged. I ensure that they provide, the management provide everything required to ensure that they work and go on with their daily activities without problems.
Yes.
That's all you have done. You've never been to core banking.
So I've not been to core banking, like working core banking, but then I've had trainings in all these aspects.
Yes, any other question?
My Lord, that's all for this witness.
Yes, Mr. Akiki, any re-examination?
My Lord, re-examination is new, my Lord. Lord, we wish to express our sincere gratitude to the court for my Lord's patience and indulgence. We know how we struggled. I think this is the third time we're able to have this witness. My Lord, we are sincerely very grateful.
Yes, DW discharge. Where is your next witness?
My Lord, that is the case of the defendant.
Registrar, give me date for adoption.
My Lord, June 24.
You said?
June 24. 24, June.
My Lord, June 24 is convenient for the parties.
Yes, please try to file your addresses in time so that we won't come and be having application for extension of time, this and that. This case is hereby adjourned to 20th day of June 2025 for adoption of final written addresses.
As the court pleases. My Lord, we are sincerely grateful. Thank you very much, my Lord.
Yes, Registrar.
My Lord, that's all for today.
Okay, Council, thank you for being with us. We have come to the end of virtual school for today.